out of it. So, firstly, nature of the Indian Constitution, you know that some say it is federal, some say it is unitary, some say it is quasi-federal. There are certain views with regard to the nature of the Indian Constitution. So, generally, constitutions are of two types, two groups. One is federal constitution, second is unitary constitution. And in federal constitution, you know that there is the division of the power between the union and states. While in unitary constitution, there is the centralization of the power. So, generally, and by few scholars, it is said that Indian Constitution is federal in nature. Indian Constitution establishes the dual polity, meaning thereby dual polity here means the two-tier system. And here the two-tier system means the central government at the one side and the state government at the other side. So, just let me tell you that Indian Constitution establishes dual polity or two-tier governmental system, central government at one level and state government at the other level. So it is called the dual polity or two-tier system because polity is running in the center and polity is running also in the states, different states. So the Constitution defines the sphere of action, area of action or jurisdiction of each level of government and makes elaborate scheme of distribution of legislative, executive and the financial power. We have gone through in this chapter which starts from article 245 where there is the distribution of the power between the center and the states. So it is defined by the Constitution being the supreme law of the land, or just you can say as we believe in the rule of law, so there should be some law or biggest law of the land which is the Constitution, and it tells how state government will work and what types and in which area the state government will have the power. Similarly, the central government, which is the owner of the whole of the country, in which area, which subject, which jurisdiction it will contain, or it will have jurisdiction over what area, what subject, what sphere. So this is the dual polity or two-tier governmental system, because at the one side we are the citizen of India, because in India there is the single citizenship, not the citizenship of the state, but we cannot ignore this fact that we are also the citizen of Haryana or just resident of Haryana, whatsoever we say, but we cannot ignore this fact that state is the entity, or we can say distinguishable or separate entity. So the whole federal system revolves around the basic core of distribution of the power. So if we try to find out the gist of the federal or federalism or federal nature of the government, then we cannot go without saying that federal system revolves around the basic core of distribution of the power. If we define the federalism, we will have to say that there is the distribution of the power between the union and the states. and it is called federalism. And we cannot say that this distribution of the power is the blind one. This is well defined, well just specified by the constitution itself. So just let us talk about the unitary constitution, and it is that in which all the power are centralized in one government, that is the central government generally. So in unitary government the whole power is given to the one government, and generally that government is the central government, or you can say that power given to a sovereign government, which is the central government, and the provinces are controlled by central government. Just like in family, a father controls the sons and the issues, daughters, similarly the central controls the states in the unitary constitutions. Whereas the federal constitution, there is the division of power between center and state governments, and there may be some family where there is the specific division of the power with regard to business, with regard to land, with regard to property, that this will be controlled by father, this will be controlled by son, this will be controlled by daughter. So in federal constitution there is the such types of the division of the power is specifically defined by the constitution. And you know that division of the power does not mean that they are separated, but they are joined. I do mean over here that both governments, central government as well as the state government, are independent in their spheres, meaning thereby the subject allotted to them or assigned to them, the jurisdiction allotted to them or assigned to them, in that respect they are independent, or they are just sovereign one. So I may, or the father can take decision on that subject which is assigned to him, meaning thereby he is independent to take decision on that subject which is his subject, while the sons are free to take decision on that subject which is assigned to them. So this is the federal constitution which makes and which declares that both are independent in their spheres. In spite of this independency, they are dependent too, because you know that India, that is Bharat, shall be the union of the states. So union state does not have power to secede from the union. So if we go further, then we will find there is the considerable differences among the jurists about the nature of Indian constitution. And you know that this differences is due to the unique nature of Indian constitution. Why unique? You will come to know when the lecture will grow or will come on the progress. So some differences among the jurists about the nature of the Indian constitution is over here. It is the fact, because one view says that it is the quasi-federal, having more unitary features than federals. So one branch of the scholar says that Indian constitution is a quasi-federal constitution having more unitary features than federal. So they say that it is more unitary than federal, meaning thereby it is giving much power to the center, not to the states, or the power which is given to the state or division of the power is camouflage or is just somewhat you can say is the deceive. So the other view is that it is a federal constitution with a strong centralizing tendency. So this view says that Indian constitution is a federal constitution. They assume it federal, they accept it federal, but they add this thing that federal constitution with a strong centralizing tendency, meaning thereby it sometime gets unitary constitution, or it becomes sometime unitary constitution, though it is a federal constitution, but sometime it strongly treats or tends towards the unitary constitution with a strong centralizing tendency, meaning thereby a strong centralizing tendency means that it gives a strong power to the center, though it is the federal where there is a division of the power, but in spite of that federalism it is having a strong centralizing tendency. According to the constitution maker, Indian constitution is a federal. As you know, Dr. Ambedkar has said, although in our constitution there is such provisions which empower the center to freeze the freedom of the states, yet it is a federal constitution. So Dr. Ambedkar says so that I hope you are getting what I mean to say up to here. If you are having any doubt up to here, you may ask any question. You are free to ask. I hope you are getting all things what I said to you. Yes, please. If you want to ask any question, you may ask. I hope that there is no question up to here, so I will just proceed further. So just these were above two reasons which I discussed with you, that Indian Article 1 uses the word union instead of federation, and this word was used deliberately because Indian Union is not result of the agreement by the state, and the states have no freedom to secede from union. And in the opinion of the Wheare, the Indian constitution is the quasi-federal. We have seen two types of constitution above, where one type of the constitution is the unitary constitution, where all power is centralized in one government, particularly in the central government. And second type of constitution is the federal constitution, and where there is the central at one side and the state government at the other side, and constitution defines their sphere of action or their area of action or their power. So these two types of the government, there is three types of the state too. That is the quasi-federal state. And quasi-federal states, it is a unitary state with subsidiary federal feature. So what is the unitary state? Unitary states with subsidiary federal features. So quasi-federal means that it is mainly unitary state where the center is given much power, but that is having subsidiary federal features, meaning thereby there is some division of the power too, rather than the federal state with subsidiary unitary features. So cases where is having such types of the opinion that Indian constitution is the quasi-federal constitution, it is the unitary, much unitary with less federal features or subsidiary federal feature rather than the federal state with the subsidiary unitary feature. Professor Jennings has described Indian constitution as the federation with a strong centralizing tendency. So Professor Jennings has defined Indian constitution as it is the federal constitution which contains the strong centralizing tendency. So while cases were quasi-federal or more unitary, while Jennings says it's federal constitution with a strong centralizing tendency. So there are just four types of the constitution which I have discussed with you, and one opinion says it is federal, second says it is just unitary constitution, third opinion says it is the quasi-federal, and fourth opinion says that a federation with a strong centralizing tendency. So different people has defined Indian constitution differently, but now if there is any doubt with regard to the nature or any article or anything with regard to the law or legal aspect, then definitely we see towards the courts. So Supreme Court in the state of the West Bengal versus Union of India 1963 has held that constitution is not fully federal, minority view. So earlier in 1963 this was the view of the Supreme Court that Indian constitution is not fully federal. Minority view of Justice Subba Rao was that constitution is federal. Justice Beg in Karnataka versus Union of India 1978, Justice Madan in Central Inland Water Transport Corporation versus Brajonath Ganguly in 1986 supported the view of Justice Subba Rao, and Subba Rao said that Indian constitution is the federal constitution, and it was in minority in the beginning, because I told you that it was the Justice Subba Rao's view was the minority view. So West Bengal's case 1963, similar Karnataka case 1978, it was the minority view, because and also in Brajonath Ganguly 1986 case, this view was supported by Justice Subba Rao, but finally in S.R. Bommai case in 1994, Supreme Court has expressed in majority opinion that Indian constitution is federal. So finally in the Bommai case establishes the Indian constitution as the federal constitution. Earlier it was the minority view that Indian constitution is a federal constitution. Similarly, one more case of Hinsa Virodhak Sangh versus Mirzapur Moti Qureshi Jamaat 2008 case held that though the country may be divided into the different states for convenience of the administration, the country is the one integral whole. So it was said with this aspect that country cannot be divided, meaning thereby Indian constitution or Indian state is the federal state where there is the division of the power, not the right to separate or right to secede from the union. So though the country may be divided in different states for the convenience of the administration, because administration or administrative efficiency is required, but in spite of it, Indian constitution or country is the one integral whole. So let us now discuss